name's Dustin Taylor, and I'm with the firm of Husch Blackwell. Today, I'm going to be talking about data privacy litigation update on wiretapping. Husch Blackwell is a firm, 800 plus attorneys across 20 offices. Our Denver location, where I sit, is at 1801 Wawata Street, Denver, Colorado, 80202. As part of Husch, I sit in our Technology, Manufacturing, and Transportation SBU, and my practice focuses on litigation, specifically patent, trademark, trade secret, and data privacy litigation. Before getting into wiretapping, I want to first discuss where are we now? As of today, there has been no federal privacy law yet. Instead, many states have passed or will soon pass privacy laws of their own. This map, is last updated of June 20th, 2023, and shows which states have enacted legislation, which have active legislation, which did not pass an act in 2023, which have excluded legislation, and which have no bill proposed. What does this mean for us? This means absent a federal private right of action, or really any state that has a private right of action, privacy plaintiffs are trying to fit a square peg into a round hole to try to capture data privacy rights. We're seeing claims in a variety of different ideologies. Claims for intrusion upon seclusion, voice recording, false advertising, claims for general invasion of privacy, claims that certain conduct violates a constitutional right to privacy, and then what have become the two biggest ones, claims that conduct violates the Video Privacy Protection Act, or VPPA, or claims that conduct violates wiretapping laws. And we're going to be talking about that second one, wiretapping, today. Wiretapping claims have been most often brought in what are considered all-party consent states. These include California, Pennsylvania, and Florida. All-party or two-party consent states require that all parties to a communication, everyone involved, consent to the conversation being recorded. Plaintiffs that bring wiretapping claims in all-party consent states have typically targeted a couple of different technologies. They typically target what is called session replay technology, which is when software monitors a website visitor's behavior. This is traditionally brought with very good intentions. For example, a website user website operator may be curious about how consumers are trying to find the contact us section. Are they clicking through multiple menus trying to find it, or is it easily findable on the homepage? Same thing on the terms of use. Are website visitors clicking through and cannot find the terms of use? Does it need to be more obvious? Or looking at their behavior, are they finding it easily enough? That technology under a variety of software providers is commonly referred to as session replay. Wiretapping claims are also typically brought against website chat features, and this is exactly what you are all thinking. Website chat feature is simply when you go onto a website and you choose to chat with a customer service. Oftentimes it may be an AI-assisted chat service that gets you through a couple of first round of questions before determining whether it needs to hand off to a live customer agent. And in these instances, a lot of times the chat service is actually provided and serviced by a third party who specializes in providing these AI-assisted or just human-assisted chat services. But to the website visitor, they are still chatting with the original website owner. We're also seeing a recent trend where the mere use of pixel technology, which is a form of advertising tracking technology, itself violates wiretapping claims, regardless of whether it's used in conjunction with session replay or website chat technologies. Because there are so many all-party consent states, we're not going to take a look at all of them today. We're instead going to look at only one, California. That's because that's where most of these claims are being brought. We are currently tracking over 200 litigations where plaintiffs have brought claims, most often under California, claiming that the use of website chat functionality violates California wiretapping law. And the California wiretapping law is found under what's called California SIPA. Specifically, it is Section 631A of the California Penal Code. And then we also see claims brought under Section 632.7 of the California Penal Code. Now, what's most obviously and immediately obvious about these two sections is they're not recent. Section 631A became effective on January 1st, 1994, whereas Section 632.7 became effective on September 27th, 1993. We'll talk a little bit more about Section 632.7 at the end of this presentation, but we're going to begin with Section 631A. Now, importantly, both of these sections provide for statutory damages not exceeding $2,500. Excuse me, $2,500. What we see in this is that you often receive a demand letter threatening class action. And each of these instances for a consumer of $2,500 in total across, for example, all of the consumers that access the website from California can quickly become a very serious amount. There are 4 avenues of Section 631A. I'm not going to read all of this to you because you can all read certainly well by this point, but we're going to be focusing on the 2 bold points here, subsection 2 and subsection 4. Subsection 2 applies to someone who willfully or without the consent of all parties, again, we're in an all-party consent state, reads or attempts to read or learn the contents or meaning of any message, report, or communication while the same is in transit or passing over any wire, line, or cable, or is being sent from or received at any place within the state. Subsection 4 creates a different cause of action against someone who aids, agrees with, employs, or conspires with any person or persons to do any of the acts mentioned above, which would include subsection 2. The common issues that we see in what I'm going to consider modern wiretapping lawsuits, meaning lawsuits brought against more modern technologies such as chat service or session replay, are follows. First of all, did you have consent? We saw on the last slide that we're requiring the consent of all parties. If you have consent, then that's a potential defense to the claim. We're also looking at what is being sent to the third party. Is the defendant or third party considered a party to the chat or not? How is that information being sent to the third party? Was the plaintiff actually harmed? Do they have standing? And which court are you in? How these questions are answered can drastically shift the potential liability in response to a modern wiretapping lawsuit in California. First thing we're going to look at is whether you have consent. As mentioned before, we're looking at all parties must consent in a 2-party consent state. Obviously, the party recording the communication is going to consent because they know what's going on and they're involved in this. What we're really looking at is whether the privacy plaintiff consented to the recording. And the case law tells us an important couple things. First, that the consent must be obtained prior to recording. The Javier v. Assurance IQ case was from the 9th Circuit in May of 2022. And in that case, this was a session replay case. The website operator had a form and they monitored what was formed. And at the end of the form there, they had a checkbox that said, by submitting this form, I consent, I agree to the website terms of use. And the website terms of use and privacy policy included disclosure that said the website is using session replay technology. This went up to the 9th Circuit, and the 9th Circuit said, okay, that may be great and all, and that may be enough for the to obtain the consent, but you were using that session replay before they ever checked that box. So as the user is entering in the forms and filling out those forms before they ever submit that information and agree to the website terms of use, the session replay technology had been in practice, and the website was capturing what the user was entering into that form. And the 9th Circuit said, there's a cause of action. Consent must be obtained prior to the use of any recording. It can't be retroactive. The next thing we've seen under the umbrella of consent is privacy policy disclosures by themselves are likely insufficient to obtain consent. And here's what we mean by that. If you have a website and there's simply a link to a privacy policy disclosure or the website terms of use at the bottom of the page that doesn't require some sort of action, you're probably not going to survive a motion, or excuse me, you're not probably going to win out on a motion to dismiss. And the Yoon v. Lululemon case, the Central District of California from 2021, examined this and said the disclosure in Lululemon's privacy policy on the presence of the third party that was running this software could not constitute consent on Yoon's part. The privacy plaintiff in that case simply pled that I never read that. I didn't know it was a thing. Next, we're going to be taking a look at what is being sent to the third party. Now, at its core, wiretapping laws are about communication and the contents of communication. That means that tracking behavior is unlikely to violate wiretapping laws. For example, the Goldstein v. Costco case from the Southern District of Florida, which is another two-party consent state, and this is a 2021 decision, found that the mere tracking of plaintiff's movements on the website did not violate the wiretapping law because it is more akin to information obtained through a security camera at a brick and mortar store than somebody eavesdropping on a communication. At its core, wiretapping laws are focused on communication. Now, this can be broadly understood to include different things, but if we're just looking at behavior, mouse clicks, movements, those types of things that would be more similar to somebody moving around a store and it's being recorded on closed circuit TV, then we're probably not in the world of wiretapping. But again, communications and contents of communications can be pretty broadly understood. Tracking any user-initiated content, including search terms, may violate wiretapping laws. And this is the Experian Info case from the Central District of California in 2021, where the court denied a motion to dismiss, where the plaintiff alleged the defendant used session replay technology to capture mouse clicks and movements, but also importantly, keystrokes, search terms, and information inputted by the plaintiff. In that case, the court said that's enough to allege contents of communication and allowed the case to proceed. The next issue we see in wiretapping cases is whether the defendant or third party is considered a party to the chat. If they are considered a party to the chat, then the party exception rule applies. And this is the Nike case, again from the Central District of California in 2021. And it says, to the extent that the plaintiff alleges the online retailer recorded its own communications with the plaintiff, then the party exemption rule applies and there wasn't going to be liability. So that begs the question, is a third-party software provider considered a party to the conversation or not? And if the answer, as with a lot of things in the law, is maybe. And I have two photos here. One is a clip art of a tape recorder, and the other one is somebody listening in. Let's look at why that matters. Two California cases have created a line onto whether a third-party software provider is going to be considered a party to the communication and eligible for the party exemption, or whether they're going to be considered an eavesdropper and not eligible for that exemption. And this is excerpt, which is pretty lengthy, and I'm not going to read all of it, but it's from the Valenzuela v. Keurig Green Mountain Inc. case from the Northern District of California just earlier this year in May. And here, the court looked at the two dividing lines of case law in California. The Rogers v. Earl Rich case, in which the defendant used a tape recorder installed into the telephone to record a conversation and then played that conversation for a third party. And the court found that there was no liability there. The defendant, who was a party to the conversation, merely was using a tool. It wasn't a third party, it was simply a tool, and those messages weren't being intercepted in transit. In contrast, in the Rebus v. Clark case, the defendant had asked someone the wife in a divorce settlement had asked the defendant to listen in via an extension to the conversation. And the California court said that was eavesdropping. So California courts are trying to apply this case law to more modern trends such as session replay and chat-based communication to ask, is this a action that's more like a tape recorder? Is this a tool? Or is this somebody who has the capability to use this information on their own? A tape recorder, unless you play it, isn't going to do anything. Whereas a person, even if they've promised not to do something, has the capability to go on and actually use that information that they had listened in and intercepted. From the Keurig Green Mountain case, that court found that the plaintiff had not adequately alleged that the chat service provider was more like a eavesdropper. They said plaintiff fails to state facts supporting their capability to use the record on their own. The plaintiff did not identify the third party at issue in the case, but merely provided a few possible software providers that the defendant may be using. Without identifying that person, they then alleged that that unknown person was integrated with Meta and had the capability to sell the customer data to Meta. That was simply unsupported, especially where the plaintiff couldn't even identify who the third party was and did not meet the plausible pleading standard. The next issue that we see in chat wiretapping cases, including chat and session replay, is how is something being sent to the third party? And this goes back to the requirement that communications be intercepted in real time. So early decisions when courts first started addressing these modern wiretapping cases, the early decision allowed the plaintiff to simply plead that the communications were intercepted. More recently, however, we've seen courts start requiring plaintiffs to plead some sort of how that interception occurs. And again, we're looking at the Keurig Green Mountain case from the Northern District earlier this year, where the court said, while is the key word here. Plaintiff alleges that the defendant's code allows the third party to secretly intercept in real time, eavesdrop upon, and store transcripts of the chat communications. But the court said, but they don't tell us how that happens. The statement does little more than restate the pleading requirement of real-time interception. Just earlier this month in June, however, another court, the Hazel v. Prudential Financial Inc. Court, again from the Northern District of California, came out differently on this issue. And here the court looked at the plaintiff's allegations, which apparently met the district's requirements of how such an interception occurred. The plaintiff here had identified who the third party was and provided some more detail regarding exactly how that interception occurred. And the court said this was sufficient to allege how an interception occurred. The next issue we see is, which court are you at? Although this can seem kind of like an overbroad, high-level question, it really does matter. Where courts are matters in a couple of ways. Obviously, the distinction between federal court and state court can matter. As we'll take a look in a minute, the federal court has an Article 3 requirement that the plaintiff actually has to have standing and show that they were harmed to maintain a lawsuit. In contrast, some state courts don't have that requirement. What court you're in also matters because, as you just saw from the interception issue a few moments ago, judges and courts within districts can draw different conclusions and reach different results on how they're going to come out on this issue and what is sufficient and what isn't. We're going to take a look at the Article 3 issue first. In the Byers v. Sterling Jewelers case from the Central District of April of this year, the court, relying on the recent Supreme Court TransUnion decision, said the plaintiffs had alleged they reasonably expected their telephone calls were not being recorded. In distinguishing a case in which the plaintiffs had alleged that. In modern, more chat-based allegations, however, the plaintiff had not made such an allegation. And the court indicated it would find any such allegation to be dubious at best. It says, well, it even appears that the plaintiff fully expected that her chat would be recorded so that she could file this action. That's why she undertook it as a privacy test plaintiff, which is a phrase that we see in a lot of these complaints. And the court also distinguished that Osgood decision, which had alleged that they reasonably expected the telephone calls to be not recorded and to be private, saying those decisions were before the Supreme Court's recent TransUnion decision. And here, post-TransUnion, the mere use or the mere recording of some sort of communication by itself, where that information is not, for example, health data or for some other reason sensitive, is not in and of itself a harm. And because plaintiff has not identified such a concrete harm, they have not established Article 3 standing, and the court dismissed it under the 12b1 standard. What court you're in also matters when we start looking at how judges are handling some of these issues and coming out at separate conclusions. Here, we're going to talk a little bit more about Section 632.7 instead of Section 631A. Section 632.7 of the California Penal Code says every person that, without the consent of all the parties, intercepts or receives or intentionally records or assists in such actions any communication, and here's the crux of Section 632.7, communication transmitted between two cellular radio telephones, a cellular radio telephone and a landline telephone, two cordless telephones, a cordless telephone and a landline phone, or a cordless telephone and a cellular radio telephone. So again, we have certain defined devices, and if communication is between two of these devices and it meets the requirements of Section 632.7, there could be liability. Courts have interpreted this differently, however, when we start getting into more modern technology of chat-based features. And we don't really see Section 632.7 in session replay cases as much, but we do see it a lot in chat-based wiretapping claims. So here we have two decisions, both of them before the Central District of California, and both of them earlier this year, one in March on the right, which is the Sinmar case, and one in April, which is the Old Navy case. I will say both of these judges have come out with additional decisions that are consistent with their holdings in this way. So don't read too much into the fact that one was in March and one was in April. We have seen additional cases kind of go onto these points and reaffirm these holdings. Judge Sykes in the Central District in the April decision said that rejected the defendant's argument that chat-based claims, you couldn't bring a Section 632 claim against a chat-based claim because at the end of the day, the device that the defendant was using was not a cellular or cordless device, but was instead a website server. And Judge Sykes looked at this and rejected the argument and says that rejected the argument that plaintiff could not allege both parties were using a qualifying telephone device. In Judge Sykes' opinion, the only thing that mattered was whether the one of the devices was cordless or cellular. In contrast, Judge Fitzgerald in the Sinmar case in March accepted that argument, and looking at the plain language of Section 632.7, said simply using a smartphone or a Wi-Fi enabled and therefore cordless laptop did not meet the standard of Section 632.7 because that language clearly requires a communication between two cordless or cellular devices. Whereas here, the defendant is using a server, which is not cordless, that Section 632.7 wouldn't apply. So which court you're in matters not only on the distinction between a federal and a state court, but also not even the distinction between whether you're in a specific district or not, but oftentimes which judge you are in front of. This discussion of wiretapping is simply one of the many ways and the many claims under which privacy plaintiffs are attempting to test the waters and bring various privacy claims. We have, again, we're tracking over 200 wiretapping claims, most of those in the state of California. We are also tracking over 50 video privacy protection claims, which we'll talk about in another session. But we're also seeing, again, health data, voice recording, false advertising, invasion of privacy, a lot of different claims. So this is a very wide field, and there are a lot of risks to any website operator. In addition to what we have currently seen, we're kind of keeping an idea on what's on the horizon. And if you read our blog at all, you will, on our data privacy litigation updates, you'll see the section called On the Horizon. For purposes of this presentation, I've renamed that to What's Next. And What's Next is from one of my favorite shows of all time, The West Wing, President Bartlett, who's on the slide here. And what's next in the world of data privacy litigation? Certainly, we're looking at the My Health, My Data Act out of Washington, which is the first state to actually include a private cause of action, and that bringing that action under the Washington Consumer Protection Act. And the My Health, My Data Act automatically says a My Health, My Data claim would satisfy the first three elements of a consumer protection claim. We're also watching to see more scrutiny on ad tracking pixels, regardless of whether they're passing on communication or whether they're tracking behavior, and how courts are going to respond to these additional claims. We're tracking and watching cases that allege violation of voice recording technology, such as California Penal Code Section 637.3. And we typically see technology that runs afoul or allegedly runs afoul of these types of claims in high security instances, such as banking, where somebody calls in and the software uses a recording of the person's earlier voice recording to identify the person. These voice recording laws typically prohibit the use of voice recording to determine the truth or falsity of a statement. So you essentially can't use a prior voice recording of you as a lie detector. And plaintiffs are alleging that this voice recording software, if you're using it to identify whether someone is who they say they are, that is using the voice recording to determine the truth or falsity of the claim. So we have seen a couple of those claims and are watching them. We've also seen issues on allegedly malfunctioning cookie banners, and another interesting one that we're kind of just catching wind of and watching closely is a claim that simply recording somebody's data and building a data profile of them is akin to misappropriating their name, image, and likeness. We haven't seen a lot of these cases really be successful yet, but it's really just hammers home that this is a very quickly moving and evolving field of litigation, and it's very important to kind of keep abreast of everything that's going on. And the final thing that we're watching is we don't know. Again, this is quickly evolving and changing rapidly, and we never know exactly what's going to happen next. If you would have asked us 5 years ago whether we would be expecting chat-based wiretapping claims to be asserted against, wiretapping claims to be asserted against chat-based communications, I don't think there was really anyone that would have said, yeah, that sounds like something that's going to happen, but that's where we are today. So again, this is extremely important to kind of just keep abreast on, continue following, continue attending webinars such as this, and stay abreast of what dangers privacy plaintiff would present to website owners. Thank you.